Well, good morning, everybody. Thank you all for coming. I hope you have had a relaxing night of sleep. I know many of you were really tired yesterday. And well, let's restart. I'd like to call Professor Michaela to come here to make her presentation. And I don't know, Stephanie, would you mind chairing this panel? Yep, wonderful. So come in.
Hi. Okay. So I don't have to moderate anything now. It's just your start.
Yeah.
Do I introduce you? It's fine. Everybody knows you. Okay. Well, thanks for having me. And again, I'm sorry to have missed yesterday. I don't really have a sort of full presentation in the sense of a very developed talk or a paper that I'm presenting that I've already written. Rather, I have a couple of more or less jumbled thoughts on which I'd like to have some reaction from you and be quite interested to hear what you think about it. So when Niels pressed me to give a title sometime earlier this year, I said I was going to speak about output legitimacy and democratic backsliding. That working? Yeah. Okay. Is this even necessary in this room? Okay. Well, all right. Since then, I've been thinking I should have rather spoken about a project on the European Court of Human Rights, but there I am. So output legitimacy and democratic backsliding. So how do I get to the topic? Well, partly from observing what's been happening in the United States, where I think the maneuvers and actions of the Trump administration have to some degree shown a new pattern in democratic erosion. New pattern. Why? Because, and I think it's a matter of degree, but if you look at what's been happening in places like Hungary and Poland and elsewhere, the descriptions we've been given in the literature is that the important thing about this kind of democratic erosion is mainly that it's done by legal means. So this is why we have different terms for it: abusive constitutionalism, autocratic legalism, and so on. And the main point of this has been to describe that the erosion that we're seeing is being done by measures of law, and it's been important to the rulers and the governments in place that it appear legal. Now, I think with the Trump administration, this kind of emphasis on appearing legal has receded into the background. And what we've been seeing instead is a more straightforward emphasis on essentially getting things done. The slogan of move fast and break things is going in that direction, obviously. And if you look at the actions in the first 4 months of the administration, we see that there's been very little effort made to sell that what's been happening is actually legal. You see that in the way, for example, procedural rules have been abandoned, thrown overboard, and so on. And I think to some degree that's a new quality because there isn't even the effort made, which would be available under US constitutional law, at least in some of these cases, to make these actions appear legal. And so what we're seeing instead is an increased emphasis on what I would call outputs, but you may choose other terms. There's a certain degree in the public talk, in particular by people like Trump himself, who's sort of replacing what I would call a public law legitimacy paradigm with a sort of more business-oriented paradigm, the language of deals, and so on. So that's what's happening in politics. The question is, of course, what will we say about that as legal scholars? And is there a sort of constitutional theory backing up of those kinds of claims? And I think if you look at the more recent US literature, the best person to look at is Adrian Vermeule. And some of you may be familiar with his work. Adrian Vermeule is a legal scholar based in Harvard, someone who has for a long time been justifying expansive executive action, including in the context of the war on terror and the Bush administration previously. But more recently, Adrian Vermeule has developed a concept of what he calls common good constitutionalism, which really involves a strong break with the traditional paradigm of democratic constitutionalism. And I think it's important to emphasize how deep that break goes. This goes back to Vermeule, for example, arguing, well, what is common good constitutionalism? Essentially, he's drawing on older, more classical theories of law and bringing back notions of natural law again into the balance, arguing that we have been overly obsessed as constitutional theorists with ensuring the right design, and what we should instead be focusing on are outputs, performance. And he's writing that very explicitly about the separation of powers, where he's arguing from the shift from a design-based understanding of separation of powers to a what he calls output or performance-based model of legitimacy. And just to give you a flavor of how far this is going, it is going as far as him arguing in a more recent, essentially blog post piece, that what the US currently really needs in order to overcome polarization in the political sphere is a podesta, meaning a foreigner who would be brought in after the model of early Italian city-states to sort of sort out the problems of the United States and overcome divisions, equipped with broad powers. So we're really leaving the realm of democracy and traditional constitutional theory here. So the break is going deep, in particular because it also involves a return, I think, to the earlier juxtaposition between terms such as legality and legitimacy, which we are familiar with from sort of Weimar debates in particular. And that is actually a debate we've left behind us in constitutional theory, and I think in most cases. So what does the division entail? Well, the idea of a constitutional legitimacy that can be juxtaposed to legality is, of course, the idea that there are certain reasons, purposes that are driving the states that we can have recourse to, which will justify doing certain things, even though they're not legal under the existing constitutional and legal arrangements. That kind of division had fallen away and does fall away, I think, generally in democratic constitutional states. Why? Because the idea of constitutionalism is that state power be legitimated by law, be legitimated by the constitution in place. And if you want to have recourse to, if you want to think about what legitimizes public power, then the idea must be grounded in the constitution and not some external theory of state or something like that. So Vermeule, to some degree, is bringing us back to that old debate, is opening up those old divisions again. And so the question I really have, and I'm asking myself, is how to engage with people like that. And that's partly actually, it's partly a question of scholarly ethics. So recently, Vermeule was part of a symposium, and a number of renowned scholars, including people like Nick Barber, sort of participated in that symposium and wrote why Vermeule is wrong. And so first question I would be asking myself, is that actually a good way to engage as a scholar in this kind of enterprise? Don't we need to draw a line somewhere? We may write why Vermeule is wrong, but sort of taking part in a symposium in which he then has a right to reply and so on, isn't that elevating what is essentially someone who is a neo-fascist thinker in some ways to a position of prominence, and something we should avoid? But that's not really what I wanted to talk about today. The other issue that I have is that I don't think it's actually quite as easy to just say Vermeule is wrong. I think Vermeule is wrong. But I think the kind of arguments he's putting forward actually do have, are resounding in other contexts where they're much more familiar and where there's a similar kind of danger attached to them. And this requires a little bit of explanation. So what do I mean? I think output logics are already very entrenched in different bits of constitutional law. And that's actually in some ways opposed to what a lot of constitutional theorists would be writing. But nevertheless, if we're looking in particular, for example, at the modern separation of powers literature, there's a great emphasis, for example, on separation of power, serving not just to restrain the state, but also to enable effective government. And with that comes a certain appeal to the need for flexibility, responsiveness, and so on. Again, I'm thinking of authors like Nick Barber, Eileen Kavanagh, to some degree, Ross Dixon. Now, first of all, I'm entirely in accordance with that literature. I think the point is well made. I do think separation of powers should be about effective governance to some degree. And I'm also open to flexibility arguments, but there must be sort of some boundaries to that. A second area where I think this kind of output thinking comes in, and I think is more relevant, is because we have extended constitutional rights and to some degree human rights as well to encompass a great deal of things that were not originally conceived to be encompassed by human rights or constitutional rights. Some scholars, Matthias Kumm and so on, talk for that reason of an era of the total constitution. And behind that notion is, of course, the idea that many, if not all, political demands today can be phrased by a creative lawyer in the language of rights, constitutional or human rights. I think you see that if you look at modern human rights discourse. One example that comes to mind, when I was in Oxford at the Bonavero Center last year, there were human rights topics discussed, and someone putting forward a paper why the right to education needs the differentiation between younger children and older children, and what the right for education precisely must entail for younger children below the ages of 10, and all the things that encompasses. So I think that's something that 50 years back, no one would have thought of this as a human rights discussion. Today, we are open to those kinds of arguments. So a lot has shifted there. And I think that's exemplary for the shifts we see in other areas. I think, and once we take that kind of human rights language seriously, we're saying we need to realize human rights. We need to make sure that human rights are effective. We do open the door to effectiveness arguments. There is now a constitutional anchor, a rights anchor, but nevertheless, essentially, we can frame the things that used to be policy consideration now often in a language of right. That is, I think, particularly true in constitutions that are considered transformative, in the sense of transforming the society in question to bring about a more fair, more just society, and do things like eradicate poverty. And I'm thinking, of course, in particular of constitutions like the South African one, but the argument isn't really confined to that kind of sphere. So the topos of transformative constitutionalism, as some of you at least will be aware, has also been applied, for example, to the Inter-American system of human rights, where there has, by people like Armin von Bogdandi, who put forward the argument that the Inter-American system is also meant to sort of essentially overcome structural deficits in human rights protection and fix broader structural problems. Now, that's all fine. And I'm not one of the people who say, oh, therefore, we need to stay away from social rights. We need to stay away from positive rights, which I think is sort of the traditional response to this kind of concern. I am fully in favor of social rights, and I think they're important, and they should be an important part of constitutionalism. But I do think there's a risk that this kind of argument on realizing, in particular, ambitious rights provisions can lead us then to disregard other rules in a constitution. And I do think we see that in the discourse over transformative constitutionalism, when there's often quite a sort of glib discussion, for example, of the role of courts and separation of powers. There's a sense that if other institutions aren't doing something, courts need to step in. And James has written a lot about this and why this is a mistake. But I think it's a broader argument. And it is an argument that is sort of very easy to make. If you're saying the Constitution should be transformative, it should help eradicate poverty, then surely the little formal procedural rules don't matter that much and shouldn't matter that much, because what matters is eradicating poverty. And so I think this is the kind of argument we need to be wary of to some degree. So we're not seeing that only in a global South context. We're also seeing it in a context of EU law. And that's, I think, something that's perhaps a little bit less familiar, but EU law is, I think, a good way of illustrating where this kind of logic can lead. So in the context of EU law, we have long had a strong emphasis on bringing about certain results, not eradicating poverty in the case of the European Union, but realizing the common market. And there are specific tools of interpretation, the so-called effet utile, the effective realization of European Union law, which have enabled the court to go quite far in interpreting the European Union's powers to bring about those results, often with sort of, well, not entirely taking rules about competences very seriously. There's also a broader sense in European law of a very flexible approach and with regard to sort of the division of competences between the Union and the member states. And some scholars have described the results of this as a governance by situation, and said the European Union essentially thrives on what he calls a normativity of distress. Alexander Somek is who I'm quoting here, who has accused the Union essentially of basically drawing on a sort of authoritarian paradigm of thinking in this regard, where principles like the Solange jurisprudence, where I'm more critical actually of his argument, I think it doesn't quite fit that, but other areas like subsidiarity, where this kind of flexible approach to competences just goes too far. Why? If we think about what subsidiarity actually means and what should be the place in subsidiarity, if you think about it, it's a very odd principle in a democratic state, right? It's a principle that says essentially lower levels should deal with something unless they can't deal with it, and the higher level is better suited to deal with the problem in question. Is that a principle on which basis we want to divide up powers in a democratic state? If the idea is that power is rooted in democratic sovereignty, sure, you can argue that they're different kind of sovereigns, and subsidiarity just replaces the sovereignty of the Union with the sovereignty of a member state. But it's nevertheless, I mean, something one could actually think about a little bit critically, whether that principle originally coming from the Catholic Church really fits democratic states and is suitable in that context. Anyway, that's going a little bit far out, but it begs, I think, the question how to sort of deal with those kinds of output logics that we have in different areas of international law and constitutional law, and how we sort of also deal with that imperative for responsiveness and collaboration that people are stressing in separation of powers, while also preserving some legal boundaries. And this is now where I'm going to reveal the answer. And the answer is, of course, that I don't have a good answer. So the best answer that I found in the literature so far has been essentially about making clear that this kind of output logic plays a role, and being very aware of its place and bringing it in some sort of balance with democratic legitimacy as the core source of legitimacy in constitutional states. That argument is put forward in the European Union by a scholar, Turkula Isiksel, who's written a book about what she calls a functionalist approach to legitimacy in the European Union. That book is not very often read, even though it's, I think, Oxford University Press. I think it's one of the best things actually written about European Union law. And her point really is a point that while this kind of output legitimacy has a place in the European Union, we need to be aware to the degree in which it pushes back against democratic legitimacy and rights protection as well, to some degree. I suspect that the answer for domestic states will have to go into a similar direction, but I'm really not clear about it. And this is my last sentence. To some degree, this is why I'm worrying about the Vermeule kind of argument. I think the Vermeule kind of argument has quite close parallels to these other arguments that we see that we will be much more sympathetic to. And this is why it's not enough to say that he's wrong, but this is why we need to come up with some way of thinking about this in a better way. All right, I'll leave it at that. Thank you very much for this.
So we do it like yesterday, that we collect some questions and then you answer. Okay, so I see you first. Yeah.
Yeah.
Thank you very much, Michaela. That in very many respects, actually, that connects to yesterday. I've actually a number of points. The first, we had concern of output legitimacy also yesterday when we discussed, for instance, environmental politics, where I would be very happy to make quite contrary arguments to what you have been saying, because I don't think that can be done in a democratic way in any state in the world, because people are not prepared to pay for the interest of future generations. No majority in no country in the world. I do also have still concerns with the erosion of democratic legitimization. But that's not only so with the European Union and the integration of markets and all that, but that's of course with the reframing of everything and anything in terms of rights. Because it's not only with social rights, it's with everything, also with education. So, and I mean, a parallel description would be the replacement of democratic decision making with judges' decision making, and that's a deep concern of private lawyers in Germany, that everything is nowadays decided by the Constitutional Court rather than within the logic of private law, by private lawyer and private law courts. There's now a long article by Marietta Auer who argues that, so to speak, the new constitutional rights discussion of private law leads to a new natural law thinking, or has features of a new natural law thinking. I do not agree, but there is some point in it. There's a lot of tension in actually what many like us think. In some point, I'm very much in front of output legitimacy, while in others, I do see and do have traditional democratic concerns. That's my connection to yesterday, and now I'm changing the role, and I'm speaking now as a historian, which I'm also. And I would say there's no reason to think that there's the end of history, and it will also not be in terms of legitimization. And we are used with the idea that democratic legitimacy is, so to speak, the best you can have. It was the goal or the aim of history, and of course the world became better by becoming, or becomes better by becoming more democratic. And as a citizen, that is also how I think. But as a historian, I regard that as deeply naive. And if that is so deeply naive, I think we should start thinking about alternatives. And it's not amoral or aethical to think about alternatives. That does not necessarily mean that alternatives are better than democratic legitimization, but perhaps we should not taboo them. And that would mean to really engage with other ideas. Quite frankly speaking, I mean, I say that now also with some irony, but I find the idea not so absurd that the only thing which can help the Americans today is something like a protestant. They won't do it, and they are so deeply politicized, and so deeply there are so deep trenches in society that I do not really see how they can do it democratically. Because I mean, in terms of political ethics, the Democratic have traditionally been not much better than the Republicans. They have also redesigned their Wahlkreise. They have also used every means to strengthen their position. They have also placed specific judges in the Supreme Court. So much of what we regard as utterly inappropriate with the Trump regime has been done in a similar way by Democrats before. So I would say that the taboos do never help, and they do not help in with this question, which does not mean that I'm in favor of neo-fascist ideas or so, but I would also say that calling for Podesta is not necessarily neo-fascist. I may not like it, but I would need some argument. And I mean, the Italian city-states, they had reasons to do that, and they actually life was much better in those cities than in most other parts of Europe in those days. But at the end of my argument at that point, it would simply be no taboo.
Second question.
Thank you, Michaela, for I think there's a very important debate that you are that you're having here. I start with a small quibble before I go into a similar direction as Niels. I'm not so sure whether your starting narrative that the Trump administration doesn't care about law is really accurate, because they unearthed these obscure 19th century laws that nobody has looked, and in order to justify, I mean, probably as a lawyer, you would say, I'm not an American lawyer. My intuition is always, okay, this is a bullshit argument, but they make a legal argument. And so far they haven't really defined, I mean, there are exceptions, but most of the time they adhere what the to what the courts are saying. They're strategic about which cases they push to the Supreme Court. So they try to push the weak cases to the Supreme Court so that the Supreme Court rules in their favor. They don't always win before the Supreme Court. So it's not like they totally disregard the law. There might be a difference in degree, but that might be because, I mean, Kaczynski and Orban are both lawyers. Trump is not. And he wants to be a businessman. He's more of a real estate, but he frames himself. So in that respect, I see the narrative might change. So law is not that important in the narrative, but that they disregard the law. Maybe you could refine that as a point. On the second one, on output legitimacy, I also think, I mean, we have output legitimacy in many rights are, we can only justify them through output legitimacy. Courts, something like an independent central bank, and people are, may argue about, but in the US we see now what the value of a relatively independent central bank is, and so on. So we have lots of institutions that are legitimized by results. So it's not just that we have a total input legitimacy. I see that probably by arguing from results, we should not be able to override certain input rules, but just totally disregarding output legitimacy. And I don't think that you're doing that. I think that's probably not helpful. And the final point, I mean, one of the reasons why we are at the point where we are at the moment, the rise of populism, and is that the state doesn't really deliver certain services that people expect from the state. So we see that the state is less and less capable of delivering these services, and that's an output argument. And we have to think about how we actually try to make the state more capable. But I would agree with Niels that we shouldn't really have the taboo and just start from the starting point. We have to stay. I think we should stay democratic as an outset institution, but reforms on bringing more output elements in that might be part of what we have to discuss in order to see how we go forward from here.
May we take a third question, or you want to answer? Okay, and Oliver?
Thank you very much, Michaela, for a very insightful presentation. When listening to you, I was reminded about a distinction between parliamentary and presidential systems, because the separation of powers argument is convincing primarily in presidential systems. A parliamentary system does not adhere to a strict separation of powers either. And in the basic law, we have no real provision that compels us to exercise something like separation of powers. Powers are simply not separated in Germany, and hence one cannot make an argument out of separation of powers in the constitutional discourse in Germany. But one easily can in the US, because the US Constitution probably is the archetype of constitution that is built on separation of powers, Article 1, Article 2, Article 3. So my question would be, is the diagnosis of those American folks and the reference cases in Europe, Hungary, Poland, I'm not sure whether it's such a good case. We have to wait. Is that a case that is fit for generalization? Democracy as a whole is in crisis? Or is that rather a case for a diagnosis presidential democracy is in a crisis?
Right. I will reply. Some very straightforward and easy questions, no problems there. All right. Let me start in order, maybe with Niels. The one without an E, right? Okay. Well, so I have a couple of replies. Environmentalism, well, I think I mostly disagree with what you said, to be fair. I think I don't disagree on the point between judges' power and democratic power. There, I share your concern. My answer to that would be, I think that's actually a problem we can handle. I think we should be distinguishing two things. I think we should have people let people have their broad theories of human rights, tell us that education involves, children having time to play. That's fine with me, but I think then there needs to be a theory of judicial review, which means that not everything that is part of the human rights discourse is something that a court can actually, that a court will scrutinize. So this is how I would draw the boundaries there. And that's kind of my works in progress for the next year to write that up, which is building on the Antrittsvorlesung as well. But so that's that. And thank you for the Marietta Auer reference. I will look at that. I hadn't seen that yet. Environmentalism, I don't think we should carve out an exception for environmentalism. I think that's very dangerous. And I don't think we have any reason to believe that a sort of more dictatorial regime will do a better job. Okay.
I'm in favor of thinking about alternatives and bringing democracy forward. That is my plaidoyer. Please do not misunderstand me at that point. And I would not simply and directly put any suggestion of any alternative into the dictatorship box. That is not helpful.
Okay. Fine. I'm partly coming to this because I recently listened to a talk by a colleague, Etamaman, who talked about how people in business speak about the environmental challenge and so on. And I think there is actually a considerable degree of people that frame environmentalism and the challenges it implies in sort of very clearly non-democratic terms. On the broader thing, I think, I mean, I see the historian's point, of course, but I think it's a mistake to draw a normative conclusion from that we should be, but I don't think we should be thinking about alternatives. I really don't. I mean, I can see about modifying democracy. I can see about tinkering with bits. I can see about how we might think about different forms of democracy, but sort of the baseline of having an equal political say in a system and equality and dignity that come with that, I don't think that's something we should question. I think that needs to remain the baseline. And so I disagree with you there, but maybe that's a conversation to have later. But therefore, I think it's important to also label these things as problematic and not engage them on purely historians' terms. I think it's opening a door to normalize certain discourses that are then going to come into constitutional law. I mean, they're going to be there anyways, right? But I think that's dangerous. And I wouldn't go down that line. Yeah. Niels. Yeah, so I mean, you're of course right. It is a more nuanced argument than the one I've put forward here. There has been sort of some arguing with law. I think the point I would make is that I do think, especially in the early months, one could have made an effort to comply a lot more with certain rules. In particular, I'm thinking of procedural rules. In order to not run into the problems that the U.S. administration has had in lower courts, right? The rates in which U.S. administration actions have been repealed and pushed back against in lower courts, I mean, partly as a matter of injunctions, TROs, and so on, but has been staggering. And some of this has been rolled back by the Supreme Court, which is deciding very differently. But I'm not sure how seriously to take the Supreme Court in that regard. But I mean, you are right, of course, that there's a certain degree of legal strategy going on. And if I were to write this up, then that is something that would have to be acknowledged. And I should also say that Kim Lane Shapley, who is, you know, by all means a better observer of the US system, disagrees with me and thinks that what we're seeing is sort of a return of the Hungarian means. My own sense has been slightly different, but second point, yeah, I don't think we disagree that much. Actually, I entirely think that output legitimacy has a place in constitutional law. I think actually, if you read people like Christoph Möllers and so on, it often doesn't. It sort of drops out of the balance, and I think there's a problem in that. And I think that's to some degree how it can then come back with a vengeance, as it were. So I do think there needs to be room for that kind of argument, and I entirely agree about that. But again, sort of being wary of how far this goes and how far to push it and not override other kinds of rules that we have in constitutional systems. How to make the state more capable is, I think, a big question. It's not also only a question for lawyers, of course, and that's perhaps something to keep in mind as well. Oliver? Yeah, I mean, there again, I disagree, I think, a little bit. So yes, there are differences between presidential and parliamentary systems. Yes, the separation of powers works different in both of these systems. Yes, we can debate of whether we even talk about powers being properly separated in a parliamentary system. To my mind, this is partly a terminological debate. I mean, I do think we have ideas of whatever you call it, checks and balances. I don't want to quibble about the term. If checks and balances works better than separation of powers, that's fine with me. But I think even in a parliamentary system, there's a sense that there's an executive branch, a legislature, and courts at the bottom line that have a certain degree of distinct tasks. And so I'm not so convinced that this is really where the problem is. And I would add that the more recent political science literature that I've read, people like Chaibub and Limongi actually partly drawing on Brazilian experiences. But that kind of literature has emphasized that the differences between presidential and parliamentary systems aren't actually as big as we used to make them out to be. So the standard argument that presidential systems are unstable and much more often lead to authoritarianism or slide into authoritarianism because they have a strong executive branch, because they have a directly elected parliament. The answer from political scientists that I've seen is that it's a lot more complicated than that. And a lot depends on individual details. What powers precisely does the president have? Does he or she have a veto right? What exactly is the relationship between the legislative branch and the president, and so on? And that we shouldn't, therefore, that the old sort of Juan Lin's diagnosis, and to some degree Bruce Ackerman, is actually not entirely correct in that absoluteness. So I would be a bit wary of drawing that distinction too rigidly or making too much of that. Yeah.
Okay, I think we have time for some more questions. Yeah. Okay, so go ahead.
Thank you, Michaela. Very insightful talk. I just would like to ask you to say more or a little bit, or to add to your analysis the special role of social media in this backlighting of new populism, and also something that comes together with this new importance of social media, which is some kind of tightening control and freedom of expression that sometimes is taken as a kind of remedy for dealing with this. And this kind of tension is something that is very, it's crucial in the current debate in Brazil, for example. So I'd like to know your thoughts on that.
Thank you. Should we collect or?
No, I think you had a second one. Okay. Yeah.
Actually rather marginal. It's not really a question about your presentation, but concerning the question, Oliver's question, the difference between parliamentary and presidential system. You mentioned the case of Brazil, and actually there is something else to consider, and this is a party system.
Yeah.
For instance, Brazilian presidential system is completely different from American system, not only because of the powers the president has, but also because of multi-party system. So Bolsonaro was head of the executive, but his party had only 10% of the house. So it's a completely different dynamics. So it's not a question, it's just a comment on the.
I think we're good. I haven't seen anyone off.
All right.
Again.
Okay.
Yeah.
Yeah.
No, okay. No, I'm fine.
Yeah, to Virgílio, I can just say I entirely agree, and that's a very important and good point. And it's actually that we're now seeing some more good research on this, I think, in comparative constitutional law, which wasn't there for a long time, and which is sort of one of the areas in which things are moving, which is good. The other question about, social media. Yeah, so I don't really have a very good answer to that. I mean, obviously, I think social media is involved in the problem of backsliding, I think, in most countries. Why? Because the sort of traditional guardians, media houses, newspapers were controlling who could say what. And to some degree, that had a moderating influence. And so certain things weren't, well, there weren't the kind of algorithms that were driving a radical speech that we see working on social media platforms. I'm not a social media expert. I mean, I think to some degree what we're seeing here might be more a question of degrees than a question of things completely changing. I think we shouldn't forget that tabloid newspapers, like since forever, have also played a problematic role in furthering certain regimes. And I remember when I was growing up, there were these studies in Germany of the Bild-Zeitung and all the things the Bild-Zeitung was printing. And I mean, there have been far-right positions advocated by the Bild-Zeitung for a long time. And so I think the traditional media also had a role to play in that kind of radicalizing thing. But it's certainly with social media, it has taken on a new dimension in the sense that it's now something that is, well, that perhaps a lot more people are following social media, and it's harder to control. So I do think that it plays an important role in nearly all the systems where we see this. In Germany, by the way, as well, TikTok is driving far-right content in Germany. With regard to what to do about that, I don't really have a good answer, I think, to be honest. I mean, it's clear, I think, that this is one of the areas where we have let global capitalism run loose for too long. And my intuitive response is to call for more state regulation. That said, I mean, that's kind of my intuitive response to most things. And it is something I noticed when I was studying in the US, that US lawyers would always ask first, why should the state be involved in regulating this question? Whereas I, as a German, thought, obviously the state should be doing this. And so maybe it's just that kind of knee-jerk response that I have. But it is something I think where we need to, where other people have better ideas than me. And I'm actually a bit not the best person to answer that. I'm sorry to disappoint you on that. Yeah, this goes back to the discussion.
Okay, thank you very much.
Good morning, everybody. I would like to say a couple of words about this is a project, it's a future project. Actually, I have no results here. I have more questions, more doubts than answers. I'm, so to say, shifting from two old research projects to a new one, and I'm starting to think about equality. And this is the title of the presentation, Equality Beyond Socioeconomic Rights. And this has an explanation because in Brazil, when we talk about substantive equality, usually think about my idea here is to argue that the realization of equality is no news here. Remains one of the key challenges for constitutionalism in the 21st century, one which requires a change in perspective in the constitutional debate on substantive equality. So I would like to give the roadmap of my presentation. There are 6 parts. I don't think I will have time to say much about last one, but if they are short parts, no problem. Don't worry. So I would like to, this is the roadmap. I would like to talk about something about the relationship between inequality and socioeconomic rights, then inequality of income and inequality of health, of wealth, then poverty and inequality, equality in tax system, inequality in courts, and then legal education. So inequality and, well, socioeconomic, the last word is right. Usually constitutional scholars who studied equality of fundamental rights see two dimensions of equality. Formal dimension, formal equality expressed in the idea of equal protection before the law. When one tries to move beyond the formal equality to substantive equality, one particular category of fundamental rights immediately comes to the fore, namely socioeconomic rights. So in other words, constitutional scholars tend to assume, at least in Brazil, I'm not talking about the whole world, in Brazil and sometimes maybe in Latin America in general, tend to assume that the promotion of substantive equality is done almost exclusively through the enforcement of socioeconomic rights, such as the right to education, right to health, right to housing, etc. And of course, there are good reasons for this. Socioeconomic rights are indeed rights aimed at reducing substantive inequality. So many constitutional democracies, public services aimed at realizing socioeconomic rights have been significantly strengthened in the last decades. In Brazil, for instance, education health policies in the last 4 decades have been expanded all the time. So how can we explain the fact that socioeconomic rights have been to some extent effectively enforced in many places, while inequality has at the same time increased almost everywhere in the same period? So in absolute terms, much more is invested in health, in education, in housing today than 40 years ago. Of course, not everywhere, not all the time. It's a trend, there are waves, etc. But so on the optimistic side, it's possible to say that the fundamental achievement of the 20th century constitutionalism in several countries, and also in Brazil, has been the consolidation of socioeconomic rights. So, but at the same time, inequality is on the rise. Why is that so? So the 2 seemingly contradictory trends coexist here. Rights designed to promote substantive equality, socioeconomic rights have been progressively realized in many places, but income and wealth inequalities have nevertheless increased. And this is true not only in such regions, unequal regions such as Latin America, Sub-Saharan Africa, Middle East, or now North Africa, also in regions that achieve considerable levels of equality in the 20th century, such as Europe. So more than half of the world's income currently goes to just 1/10 of the world's population. And the poorest half of the world's population receives less than 10% of the income. So this is what's there. And even more dramatic is the situation in wealth. No, not income, but wealth inequality. So the poorest half of the world's population owns just 2%, say. 50% of the world population owns 2% of total wealth, while the richest 10% own more than 75% of it. And among the richest, there is an extreme concentration of wealth in the richest 1%, who owns more than half of what the richest 10% owns. 38% of the world's total wealth belongs to this group of the richest 1%. One can, of course, ask, well, this is a global South issue. It's something that those unequal regions such as Latin America, Sub-Saharan Africa, or Middle East, etc. And actually, no. Of course, the degree of concentration of wealth and income is not the same around the world, but it's not a global South issue. So Europe, of course, remains the most egalitarian region in the world, albeit with considerable differences between countries. But the difference between Europe and other regions can be less significant than is usually assumed, and certainly smaller than they used to be. And this is only talking about the present, but it's interesting to consider the passing of time. So more equal regions in the past are less equal in the present. So we can, as a colloquium with German, with Regan, scholar, this is it's hard to read there, but this, yeah, everything's going fine today. This is income inequality in Germany. So 1980, 2019, so income inequality is on the rise in Germany. And it's interesting when we see income inequality post-tax, after tax. So after tax, the situation was much better in the past and much worse in the present. I have no time to present all the data here. And this is wealth concentration and wealth inequality. So the top 10%, almost 60% of the wealth, and the bottom 50%, something like 5% of wealth. In such an egalitarian country like Germany. In Brazil, it's of course much worse, much worse. So we could say here, we discussed just a little bit about the relationship between poverty and inequality. So at this point, one might, of course, ask, does income and wealth inequality really matter? So if the worst off, the poor, are less poor today than they were 40 years ago, what is the problem if the rich became even richer, not only in absolute terms, but also in relative terms, relative to the poorest? If the rise in inequality also benefit the least well off, what could be the problem? Of course, there's no time here to discussion on the matter, or discussing Rawls' difference principles, etc. But I would like to address some effects of inequality that they are independent from poverty. So at least this is the first more general one. So inequality undermines the social fabric by eroding shared values, reducing the sense of belonging, and dropping social trust and cohesion. This hasn't to do with poverty. This has to do with inequality. So even in rich countries, inequality may bring about these problems: eroding shared values, reducing the sense of belonging, dropping social trust and cohesion. But we can, of course, be more specific than this, more specific than eroding the social fabric. And I will just mention two areas in which inequality and not poverty, well, poverty is always a problem, but inequality is a problem as such. And this, the first one is support for democracy. There are lots of studies showing that support for democracy is less strong in unequal countries. It doesn't matter whether they are rich or poor countries. What matters most is if they are unequal countries or equal. So the USA is, of course, a very, very, very rich country, but also unequal. And support for democracy is not that strong as it used to be in the past. The same applies for many other countries. There are lots of studies. Of course, we can discuss how conclusive these studies are, et cetera, et cetera. We don't have time for this, but this is an important issue. And a second issue is inequality and environmental protection. So if we look at another key challenge for the 21st century, protection of the environment, inequality has a devastating effect. The rich cause much more damage and the poor suffer more from that damage. And in this sense, the sentence, it's usually possible to replace people with countries, but the equation still holds. Rich countries cause more harm, poor countries tend to be the main victims of such harm. Lots of studies on the matter as well. It's not quite here to address this. So, how, again, how can we explain that the provision of public services in the area of socioeconomic rights in Brazil and Latin America in general are much better today, much more efficient today than 50 or 40 years ago, and the inequality rates didn't change a bit. We are just as an unequal society as we were 40 years ago. So people have more access to education, to health, to housing, to food, but these simply didn't change a bit in the inequality. So in wealth inequality in Brazil, the scenario is rather dramatic. In 2000, the top 10% held 73% of Brazil's wealth, while the bottom 50% held just 1% of wealth. By 2020, so 20 years later, the top 10% increased their share to 79%, while the bottom half, so half of the population in Brazil had minus 0.4. That means on average, this group has more debts than assets. This is inequality in Brazil, although public service and health, again, in education, etc., increased and increasing. Why is this so? Of course, Brazil has a very problematic tax system. For instance, read this here. Okay, again. So income tax in Brazil is only slightly progressive. Top tax rate is only 27.5%, meaning that middle-class workers pay the same percentage of their income as multimillionaires. Additionally, almost half of all tax revenues in Brazil come from consumption taxes, which tend to be highly regressive. And finally, there is no taxation of profits. Wages are taxed, profits are not. And perhaps the most problematic issue, if one is concerned about the effect of intergenerational inequality, the tax rate on gifts and inheritances is only 4% in most Brazilian states. I can give all my wealth, not that big, but to my kids, and I will pay almost no taxes at all. So this is the situation, not only in Brazil, but in many, many countries. And even if I accept that socioeconomic rights are not sufficient to promote substantive equality, at that not only poverty, but also income and wealth inequalities are relevant constitutional problems, this says actually nothing about which institutions are responsible for changing the status quo of inequality. So to talk about means of reducing inequalities is usually to talk about public policy, area in which institutional capacities of courts are actually limited. So what could be the role of courts or of a constitutional court in thinking about inequality, the relationship between inequality and the tax system? Of course, it seems beyond the power of a court to decide that the income or wealth tax rates should be higher than they are today. It will be hard to imagine a court deciding that the income tax rate in Brazil should be raised from 25 to 45%. It's perhaps less clear whether courts should refrain altogether from reviewing changes in those rates if they unreasonably affect the promotion of equality. So consider the following example. In December 2022, the legislature of the state of São Paulo, the wealthiest state in Brazil, approved the bill to reduce the tax on gifts and inheritance from 4% to 0.5%. So the state government actually eventually vetoed the bill. But suppose he had not. Simple question, could the Brazilian Supreme Court have reviewed the constitutionality of that statute and declared it unconstitutional on the grounds that it potentially increased wealth inequalities and is therefore incompatible with the constitution that provides that one of the fundamental objectives of the Brazilian Republic is to eradicate poverty and standard living conditions, to eradicate poverty and to reduce social and regional inequality? I believe there are good reasons to argue that the court could have reviewed that statute. I'm not really sure what could the court, what could be the outcome of this review. But I don't think there is a reason to say courts should refrain from reviewing tax legislation. Tax legislation is a matter of politics, especially in highly unequal countries such as Brazil, but not only Brazil. Actually, as I said, inequality of wealth and income is on the rise all over the world, not only in Brazil. And there is an institutional dimension involved here. This is primarily a matter of politics, executive and legislative. But of course, we should ask, what role could courts play? And I just want to add a final word on legal education. Constitutional law classes and constitutional law lectures and constitutional law books almost never in Brazil, but suppose also other countries as well. But in Brazil, almost never established a link between tax system and equality. So tax system is a matter for tax lawyer. And of course, tax law lectures are not about equality or inequality, so about to understand the tax system and maybe how to save money if you should plan your tax declaration. So I think if I could stop with the provocative idea, I think it's time to rescue the tax system from the tax lawyers and bring it back to constitutional lawyers. I think tax system is a matter of constitutional law, is a matter of fundamental right. So if constitutional scholars and actually also constitutional judges, I don't know, are concerned about the pernicious effect of the global rise in income and wealth inequality in recent decades, then I think thinking about ways of achieving a fair and more distributive tax system is long overdue. Equality as a fundamental right will remain only formal equality, never substantive equality and equality of opportunity, if the need where a tax system reform is not taken seriously by constitutional lawyers, not only by tax lawyers. Thank you very much. Sorry for the
Thank
math.
you.
Yeah, I don't know
We-
which version
will
of my
prepare a little
presentation.
bit.
went. Okay.
in the
Sorry.
in the break. Oh, okay. I see a lot of questions. So
I have no answers. Just to say I have
Great
no answer.
question. Get it. Okay, I start at the left again. Niels and Niels. You say stop if we don't want to collect anymore.
Okay.
Maybe too many
Reach
questions.
out.
Yeah.
Thank you very much, Virgílio. I agree with very many of your points, and that was quite important. Well, with regard, I always ask myself, I mean, it's in a sense obvious that the present state of affair is totally unjust, totally unfair, and in many respects unbearable. My intuitive question was, what gives those very few poor, rich people the power and the influence to protect their property? Why do societies not simply go there and take it? Yeah, yes, in a sense, what we must understand that, and if we understand it, we can address the issue. But of course, from a lawyer's perspective, the question must be the constitutional court and constitutional review. And the standard answer is probably, it relates to Michaela's paper. The standard answer is that we want to have it decided by democratic means, rather than on an output legitimacy basis by a court. And in some sense, one could agree with that. I mean, tax laws should, in some sense, be decided, and the fair distribution of burden in society should be decided by the democratic legislator, because that is, in a sense, the core of parliament, decision making. But, and that was is a question which came to my mind. I mean, a court could simply say that the present result of inequality in society and the tax burden of average lower class people or middle class people in comparison with the tax burden of the richest in society is unacceptable, simply as a result, and that the legislator would be free to provide in by whichever means for a fairer distribution of wealth in society. Why do you have an answer? Why lawyers are reluctant to give this answer? Why courts are reluctant to give this answer all over the world? I mean, we must understand it in order to address it.
Yeah.
So I also agree with Niels that there's an important and interesting paper. I have 3 points, I think. So the first one is, I think we discussed this over lunch in Brasilia, that actually in Germany, there's a very important strand of equality case law by the Constitutional Court that deals with tax issues. Even though it's often much more technical, it wouldn't raise the tax rate or lower the tax rate. Usually, I think it's mostly about, if at all, mostly about lowering tax rates and about increasing tax rates. But maybe that could be a source of inspiration in certain ways. The second point on equality, and I would agree with Niels. What's probably going on here as a political economy question is that the rich have too much influence for whatever reasons, and you probably know the Brazilian system much better than I do. Probably many of the people who sit in parliament often come from better positioned social classes. If that's the case, then if we go to Oliver's paper yesterday, then would be, I mean, he had this climate change example with lobbying, and it would be a similar concern, at least that's my intuition, that could that could justify a court intervention in this case. Now, I was wondering in your example on the Sao Paulo inheritance tax, if the court strikes down lowering from 4% to 0.5%, is that all that different from the court asking the legislature to raise it from 4 to 8%? Because the concept, I mean, it's probably a positive obligation of the legislature. And if we derive a prohibition to lower it from a positive obligation, then we can probably also make, and then the question, of course, would be, and that's different from the climate change story yesterday, where the court only said, okay, you have the obligation to lower it, but the means are up to you. But if we go to tax law and the court says, well, the tax rate should be 35% or 45%, that's of course, courts might feel much more uncomfortable about this. So maybe there's a middle ground that courts can strike to have a more vague ruling, but still oblige the legislature to do something. The final point is a very small one. Already talking too much, Stefanie, looking at me. So on the framing of the paper, so you started with the Brazilian story and then you brought global data, and I was a bit lost with the data. So I think maybe you should stick to, if you keep it as a Brazilian story, then you should probably stick to the Brazilian data.
Yeah.
We had another question there. I think it was you, yeah. Yeah.
Oh, it's not, I guess it's a sort of a question, but on the part you said about how the courts may intervene or somehow tackle the problem of inequality, I just worry a bit about how that might compromise the institutional separation of powers, and how that compromise, because we are already facing a problem of judiciary hyperinflation and agglutin, and especially the Constitutional Court. It's very, like, it's a public perception that we're like, it's having to compensate the parliamentary paralysis on about deciding about legislature and things like that. So I guess my question would be, how can I guess how far should we allow the judiciary to compensate the parliament, and if there's any concrete way to, like, make the parliament do what it's supposed to do, because it's frankly frustrating. It's like I'm very much cynical about the possible answers to this, because
Don't.
cynicism is a big problem for me. Anyway, that's my question, and here's the next one.
Maybe we do a second round.
yeah.
Otherwise,
Yeah,
we have like.
I'll try to answer
Okay, perfect.
very. So thank you very much, Niels. So why? Because why don't we have a revolution? Actually, the revolution is the only way out. And this actually, why don't we have a bigger change? I think this is an illustration of why the problem is not poverty. The problem is inequality, because the richest are powerful, and even if you say, well, but the poorest are less poor today than they were 50 years ago, it doesn't matter. They don't have access to power. They don't have the power is still limited to the richest, and this is an effect of inequality. The institutional issue, that is the most problematic issue now. Inequality in courts. I think, as you said, a constitutional court could easily say, well, the state of affairs is unjust. The amount of tax that poor pays unfair if you compare it to the rich, etc., etc. And the court could say the legislature should do something, should reform the tax system in order to make it more distributive and more progressive, etc., or should do something. And this has to do with Oliver said the court should not establish the means, but only the goal. The goal is make a better tax system. The question, of course, is if this is enough, and if the legislature can simply ignore it and say, well, we'll try, but we'll probably won't succeed, but we tried. So the task was performed. But I think this is the first step, establish goals, not means. Just say, we need a better tax system. Okay. The other news, well, you could say when the legislature is captured by an elite, there is more reason for a court to step in. And I think this is the case in Brazil. Actually, this is the case in almost every country in the world, but it's definitely the case in Brazil. But again, we ended in the most problematic question is how should the court step in? Defining goals, defining means and goals, or defining goals and monitoring the means, etc. And then you ask, well, if I think that it will be no problem if the court strike down the statute that lower the tax rate from 4 to 0.5. What's the difference for a court to say, okay, now you should raise from 4 to 8%? I think there is a difference, because in this case, at least, there is a difference, because in the first scenario, the court was what some people call negative legislation. So there was a reform and the court struck down. It's different to say no reform, but you have to raise the tax rate. So there's an important difference here. I'm not sure if this difference is definitive, but there is a difference. So yeah, concerning the data on Germany, it was just an illustration. My main focus is, of course, Brazil, but I want also I also take into consideration that the rise of inequality is not the Brazilian issue. It's also an issue even in those regions of the world where with egalitarian past, those countries are becoming more inegalitarian. So, but it was a mess here. Okay, how interventions of court might compromise separation of powers. Brazilian court is already too powerful. Yes, we're back to the same issue. I don't know. I really don't know. But I think that there are reasons for a court to step in, but I still don't know how. And especially in the case of Brazil, because they are already too powerful. So more power might be a problem. So
Okay, take them out. So
just-
Manuela? Yeah, and then. So not
Yeah, Jim, yeah.
Sorry. All right. So
Oh, I need you for against the tax lawyer.
you have my full support against the tax lawyers. But since I was on holiday here, I did a lot of reading historical fiction, not very, useful books. But the one useful book that I read on the beach in Ubatuba partly was the little conversation Piketty Sandel on equality. And so one of the things I found interesting, and I was wondering if you were thinking about that too, is that what matters about inequality at the moment isn't just the vast differences of wealth, which are a problem, but also what you can do with that kind of wealth. So the question, for example, can we take the educational system, can we take the health system out of areas where money matters? And so I was wondering if that would be something for you to think about as well. So is it possible also to deal with the equality aspect by saying well, access to education in our system shouldn't be a matter of, well, no private schools, essentially, no private healthcare. So is that an angle, or is that just too far removed from the political realities in Brazil? And the last, and one connecting question, I mean, one of the aspects that's been raised, why isn't more done politically? And you said the rich control the power. I mean, that would sound to me like a sort of Roberto Gagarella argument back into the engine room. So is there anything we can do in the engine room? I'll leave it at that.
Professor Virgílio,
Yes.
congratulate your lecture. Very interesting again to see and to hear you. And my question is maybe almost the same of the colleague that speaks about deception. And I am worried about it. And I will ask you if you think that in the court should have an aggressive posture to implement social rights, or should it act with self-contention because he has the means to declare the unconstitutionality? And I agree with your remarks about the problem of economical rights and social inequality, but I am a little bit fearful that as the court has no means to fulfill what it declares, it could come again the lack of credibility. And then it comes the question that comes in the mind maybe for everybody. What comes next? When we became the answer of the court and the answer is right, but it could not be fulfilled. Okay, thank you. Congratulations again.
Thank you.
I know, but it was pretty much the same
Okay.
time. So we just continue to go.
Okay.
Ronaldo.
Well, a very short question about the issue of taxation. Many authors claim that the biggest problem in terms of taxation should never be separated from the expenditures. So sometimes a tax system like VAT might be very regressive, and the problem is not really on this regressiveness, but rather on how the money returns to the poor ones. So, and sometimes I think this is a kind of mental habit that is very strong here in Brazil, because there are many dimensions from which you can say that our tax system is unfair, but it's not so obvious that making it fairer in terms of raising taxes for the rich poor would be the most efficient system to diminish inequality, and maybe focusing on a fair balance between taxation and expenditures would be a wiser way to tackle the problem, instead of simply saying that a tax system that is regressive is a bad one. And the VAT is a very good example of a regressive tax, which, I mean, it's adopted by many countries for many different reasons, because it's efficient, it's easier to control, and but it all depends on how we spend the money later.
And we'll be a little bit later, so we go through.
So just a short question. You depicted inequality as a danger for social fabric of a society, lacking sense of belonging, etc. Now, I live in Switzerland, and Switzerland is a country where the inequality as regards the income is not so bad, but the inequality of wealth is very high. It's rising. You know, rich people tend to marry other rich people and then inherit from their rich parents. And still, people in Switzerland in general are satisfied to live in the best possible world. That is to say, there might be other reasons for social unrest or satisfaction. In this case, it might be true federalism and direct democracy, and not inequality.
Thank you. Thank you, Professor. It was great. And I have two questions actually. The first one is, and first a disclaimer, I agree with your analysis and your conclusion, but working in a law firm that defends the rich, the first thing I know the clients would say is, yeah, okay, we should be a more equal country, but the Constitution also protects our private property. So what are the grounds that a court should rule on how a tax should be? And my second question, and I know as a matter of fact that our taxation system should be better. But my second question is about the Brazilian context. The government proposed the taxation of green agribusiness bonds here in Brazil, and also the taxation of investment funds that usually only millionaires can invest. And it was a mess in the Congress. The discussions were so heated. And my question is there a proper moment that a court could rule for more taxes when our political system, and especially the Congress, is saying, okay, we don't want more taxes. And I think it maybe create a constitutional crisis between these two powers.
The moment is surely not now. Sorry.
Stop the the second round, and then we do a third round because we have enough time. We have just 3
Really?
minutes. Yeah.
Okay.
Yeah.
Okay. Oh, it's counting on the bell. Okay. Michaela, yeah, the idea of no private schools. Well, for instance, take health and education from areas where money decide on money. The issue is, of course, I think it's a wonderful idea. Concerning Brazilian experience, the thing is, the Constitution itself, both for education and for health, has a provision say private education is allowed, private health system remains allowed. Yes, you could make public schools so good that it will be not a smart choice to send your kids to a private school. Yes, and this will bring about an improvement. Yes, but I don't think that this targets the issue of inequality, because this is what has been happening in the last 40 years. Of course, public schools are still not as good as some private schools. Public health is not as good as usually private health, but much better than 40 years ago. And this didn't change anything in the inequality scenario. So people have better access to health and education, but they're still as distant from the rich, or more distant from the rich than they were 40 years ago. And this, even if, let's say, even if the public health system, the public education system in Brazil were perfect, if the distance between the poor and the rich remain, then you still have the problem of power and everything. So, but of course, if this is one, I don't think this different solutions are mutually exclusive. Of course. Okay, the court should be activist or restrain itself. I think this is the $1 million question, and it depends on the moment. For instance, now it's not the moment to do anything more activist. The court is already under attack. But I'm taking the context, setting the context aside. But I think I have always been very critical on the effects of judicialization of socioeconomic rights in Brazil. Usually the effects of the judicial decisions are regressive. They benefit the middle class, not the really poor. But I think the ways and the effects of the intervention of the court are different. If I'm speaking of socioeconomic rights or tax legislation, socioeconomic rights are great. The realization of socioeconomic rights is a really complex task that demands complex public policies, and usually the courts have no idea what they're doing. They're sometimes taken from the poor and given to the rich. And tax legislation is something completely different. So, of course, I don't want to be naive, but tax legislation as well. Now we have 27.5% tax rate, income tax. And if I change it to 40%, this will bring about some results. This doesn't depend on public policy, of course, impacting all areas of society. I know it's not simple, but I think the intervention of the court is different in those. One is legislation, the other is public policy, and the capacity of the court is different in those areas. For now, the expenditure, yeah, but I think expenditure targets, again, only poverty, not inequality. With this tax system, it doesn't matter how good or how bad the expenditure is, that the difference between rich and poor will remain. And this is a problem as such. This is it's not my main point, but it's one important point to say, well, fighting poverty is very important. And it's good that the poor is less poor now than 40 years ago. That's really good. But it's still a problem that they are much more distant rich than they were 40 years ago. Not final, the erosion of the social fabric. Yeah, of course, I don't think that inequality is the only reason or the only cause of erosion of the social fabric. You can have some, especially when it comes to wealth inequality. It is possible to a scenario in which in a country with high wealth inequality and nevertheless social cohesion, etc. But maybe this is a Swiss. Swiss is the only example, if it is an example. But I don't know any other Scandinavian countries. Maybe I don't know. But in general, high rates of inequality amounts to problems in erosion in the social fabric. Okay, last one, grounds for change. I don't know anymore. It was your question from the tax lawyer that you're a tax lawyer for rich people. Yeah, the grounds. So on which grounds could the court intervene? The ground is called Constitution. The Constitution said what tax system should be progressive, and you can argue with 27.5%. This is no progressive. This is no progression. If I, as a professor, pay the same amount, or even more sometimes, that multimillionaire, this is not a progressive tax system, so it's unconstitutional. And of course, also the Constitution say, well, one of the goals of the politics in Brazil should be reducing inequality and not enhancing. So you have grounds. I think the problem is, I don't think the problems lie on which grounds to use, but this is an institutional issue. So which moment, how to do it, establishing goals, establishing means, and which context. Should I talk to the legislature first? Should we have a dinner? I don't know. I think the problem is much more this than reasons, legal reasons to do it. If we have enough in the Constitution.
Okay. So, yeah, some more minute. I think, James, you had a question, and Oliver, you right? Okay. You had another
I
question.
was counting on you to end this terror here. but,
Yeah, you
okay.
think- it's interesting.
No.
The people ask questions
No, no,
because
no,
it's
yeah.
interesting. So and we.
Yeah.
Okay. Just short questions, and short answers.
Short
so.
and easy question.
Yes, I will observe the inequality of question time allocated to those who speak early and those who speak late. It's shocking.
Yeah.
So the short version of this. So obviously, I'm very sympathetic to this line of inquiry and have been thinking about it for a while in the context of South Africa, which of course is even more unequal than Brazil.
Yeah.
In fact, the gap between Brazil and South Africa is nearly as big as the gap between Brazil and Germany in Gini coefficient. It's that bad. The short version of the question is this, that I think it would be useful for you to clarify what role socioeconomic rights and rights in general are playing in your argument.
Okay.
Is your conclusion socioeconomic rights are concerned with poverty? Poverty isn't the problem, therefore we should move away from socioeconomic rights?
No. Okay.
Or you're trying to make a different kind of socioeconomic rights argument? If so, that's interesting. Equality as a right is interestingly absent from your argument.
Mm-hmm.
Sure, a lot of the time we talk about discrimination in relation to equality, and that's not quite so easy to use as a frame for this. But why would we insist that equality is only about discrimination? Or alternatively, again, is this really an argument about a core of much more classical rights or constitutional things? And this goes, I think, to Gerald's question. How much is this about civic solidarity and democracy and things like that? In which case, it's a different set of rights again. And it's not clear to me, you seem to reference all of those things without telling us which hook you want to place it on.
Okay.
Or, and this might be a promising direction, if the answer is all of the above, and you need us to give us a constitutional concept that is an amalgam of these things. That might be the truest reflection of the issue you're talking about.
Yeah.
As Nielspetersen already
Yeah.
as Nielspetersen has mentioned already, we have some record of constitutional jurisprudence concerning tax law. Yeah. And those are actually very interesting cases. The thing is closed now. It had to do with the personal interest of some of the justices at the German Federal Constitutional Court. Now they have been replaced, and other personnel on the bench, and since then the tax issues have become less relevant, I would say. So it has something to do not so much with structural issues, but also with personal interests, actually. So this tells us also a story of personal influence on jurisprudential issues. Yeah. So I just want to bring that up to complete the picture. The ambivalence in the German tax law record accounts probably for the unwillingness of the German court to really dictate new tax laws. It was always very reluctant to do or to dictate laws. But the court actually did, and that was also a kind of political agenda setting. It said the Constitution, and that was derived from equality arguments, the Constitution requires a certain amount of consequentialism. If the state has a tax law, it must set the law up in a consequential way, and it must be enforced consequentially. That means if we tax people, there must be a justification. The usual justification is, in German one says Leistungsprinzip. Leistung is always very difficult to translate into English, I think. I don't know, it's an outcome performance or whatever. I don't know how to translate Leistung, actually. So the better you come out, the more you have to contribute to the social good then. And so that is one constitutional obligation, and hence the statute must refer to that constitutional obligation. If then the legislator says, well, the very rich have to contribute more because their output is more, this again contrasts with the consequentiality. Because you cannot say if those who have 50% more, they have to pay 50% more taxes. Actually, they should pay 80% more taxes and so on. So this all is very intriguing jurisprudence. I just want to say that would be my argument. Do not put too much hope into the constitutionalization of tax law, because you don't know how it comes out. It might come out the other way.
Okay.
Virgílio, it was very interesting to hear you. I don't have exactly a question, just a remark that the Supreme Court decided on the homotransphobia case using equality.
Yeah.
That the court itself could create a crime figure. So if it could create a crime figure,
Taxes.
taxes just something,
peanuts.
a detail, yeah. That was that.
Yeah.
Thank you, Professor, for the lecture. I was wondering if you thought about other ways in which our tax system could impact equality, democracy in general, because now speaking as the former tax lawyer for rich people,
Okay.
there's
Yeah. Okay.
there's a point when you talk about philanthropy, that are not only you have a lot of, like, the Brazilian tax system provides for a lot of tax exemptions when rich people donate to social projects in general. And the thing is that for me, the problem is not that you're increasing inequality when you do that, or that's not the only problem. The problem is that you kind of transfer the centers where the decisions are made regarding public policy will lead to private actors. Even like if I'm not mistaken, the bill you mentioned that was struck later, it provided for an exemption for all donations to all gifts to nonprofits, and it was quite celebrated by civil society in general. So maybe there's another like pointing to not only like increasing equality, but also eroding the state in general.
Okay. That's it.
That's it.
We
would say
really
last
have
one,
to,
but-
okay, I have 30 seconds, I think. I have no idea where, okay. James, yeah, very easy. And my answer is all of the above. That was an option. Yeah, there was an option. Yeah, actually, it was all of the above. And I'm not claiming that we should change what we have been doing concerning social economic rights, etc. But I think that we should add new layers on the debate, equality and inequality here. So I would need at least 3 hours to say more interesting things about it. But I would say it's all of the above. And I know that this creates a challenge for me. That's what I'm considering doing in the future. But the answer is all of the above. Everything. Oliver, yeah, German cases. I forgot to mention in my answer well, I have to be really brief here. Don't put too much hope in the constitutionalization. The outcome. Yeah, I agree with you. This is actually my most difficult issue here. Is I think it's this institutional issue, the role of courts, and I have actually, I may be honest, I have no clear idea where I'm going in this institutional issue, and what will be the result of claiming that tax law should be also constitutional law, and tax system should be also discussed in courts. I have no idea. So okay, wow, lots of questions. Yeah, Elena, yeah, if the court can create a crime, raising the tax rate will be easy peasy. I know, yeah, but it will also very, very controversial to create a crime out of nowhere just based on equality, anti-discrimination, and yeah. But thank you. Again, about tax exemption. Yeah, you're right. It is another problem. So with tax exemption, first, there are actually two problems here. One is private sector is deciding where the money should be invested. It is a huge problem. I know that people love this in the US, and the rich people in Brazil love what the people in the US love. But it's of course a huge problem to decide. Yeah, there is a second problem with tax exemption, because in Brazil you can, how to say in English, deduct, costs and health and education in your tax declaration. So the rich people are sending their kids to private school, to using private health system, and we are paying. We are paying. The poor are paying the school for the rich and the health for the rich. And this is I don't know what it is. I have no adjective for this. And they say, well, our kids then will study at University of Sao Paulo because they have merits. They're very intelligent because the poor are paying now for our school. So, okay, sorry.
Okay, I think that I have a last remark, and then it's your
okay.
turn.
Really?
Okay. Oh no! Okay,
No,
you're done. You're done. No,
we're done with.
We have one hour and so, and you just.
No, if you want to, but we can discuss it later.
Yeah.
Okay.
I
Yes.
Okay, last talk for this morning from Niels. And calm down, sit down, silentium.
So thank you so much. Thank you so much to Ronaldo for organizing this. Ronaldo, Virgílio, everyone here in the at USP for organizing this. I think it's really great, and I really find fascinating how the different papers talk to each other. I think my paper ties in quite nicely with Michaela's in a certain way, as you will see, and it also has a commonality on this panel that it's some early thought. So there's no developed paper here, but it's some thoughts that I'm putting out here. Maybe a bit of context. It's for a presentation that I have to give. I think it's in early November for French-German constitutional law conference. So I was asked to think about the topic, and that's how I basically interpret this. And the question that I was asked is, I should think about fragmentation, and it's on different levels, but I was given the task to think about fragmentation in the European Parliament. And now the research question that I've made out of this assignment was, is fragmentation in the European Parliament really a problem? So we would think, why not? I mean, fragmentation, at least the German lawyer thinks fragmentation is always a problem, because we have seen in the Weimar Republic how fragmentation led to the increasing dysfunctioning of parliament, and then which was one reason that contributed to the turn to authoritarianism. Now, I think that we can draw some lessons from the debate between presidentialism and parliamentarism that Oliver already alluded to in the discussion of Michaela's paper. And there's usually a tension. So people who discuss parliamentarism and presidentialism, so the disadvantage of presidentialism is usually concentration of executive power in one person. Michaela is totally right. You can have different designs of this, and you can limit maybe the damage of this, but that's usually the big disadvantage of presidentialism. Now, the big advantage of presidentialism, at least that's what the literature claims, is separation of powers. So there's a stricter separation of powers between the executive branch and the legislative branch and the judicial branch. I think there's not such a difference. Now we can ask, so what is separation of powers anyways about? Do we need separation of powers really? And what I found the most compelling argument for separation of powers is how it changes the role of the legislature. So in a parliamentarian system, the role of the legislature is legislating, but also controlling the executive. While in a presidentialist system, the parliament usually doesn't have the role to control the executive. In most presidential systems, there's no vote of confidence of the government. The president is elected by the people, and maybe there's impeachment or so, but that's a different way. It usually has higher quora of vote quora. It has very limited grounds usually, but in principle, the parliament doesn't control or only has a limited control over the executive. Now, what is the difference here? So that if we have control of the executive by parliament, we need a stable coalition in parliament. We need a coalition of parties that supports the government, because if the government loses the majority, then it will soon be out of office. Depends a bit on the design, on what actually the requirements are, but we need a stable coalition supporting the government. That also means that parties cannot build dynamic coalitions in parliamentary systems, cannot build dynamic coalitions that support individual issues. Why is that? Well, because we usually have coalition negotiations that in order to form a government, and it's a package deal. So we may compromise. One party gives in this position because they might not like this, but they say, okay, in order for me to get this, I give you this. So it's a negotiated deal that the coalition forms. That means that coalition partners cannot easily deviate and maybe support an opposition initiative because that would undermine the trust, that would undermine the previously negotiated deal, and that would also undermine the trust of the coalition partners in each other. So we need a stable coalition. This is different in a strict separation of powers system, which we usually have in a presidentialist system, where we can build dynamic coalitions, issue-oriented dynamic coalitions. And that's easier because you only have to build a coalition for a specific legislative project. You don't have to build a coalition across very different issues. And now my argument is that fragmentation, if you have issue-oriented coalitions, is less of a problem than if you have if you need a stable coalition over very different issues. Because the more you increase the size of parties, the more difficult it gets to come to an agreement on any point. But if it's one specific issue, it's still easier to come to an agreement, even if we have many parties, than if you have to build a stable coalition of many parties across very different issues. And now that brings me to the European Parliament, because the European Parliament, in principle, is not a presidentialist system. It's a parliamentarian system in many ways, but there are some quirks in the European Parliament. For example, a vote of non-confidence of the Commission needs a 2/3 majority in the European Parliament, unlike in most other systems where you need a simple or absolute majority. But you need a 2/3 majority, and that stabilizes the role of the Commission. That means we don't need a party coalition that supports the European Commission. And that's also what we see in practice. We don't have a party coalition that supports the Commission. I mean, we need one initial coalition to vote the Commission into office, but afterwards we don't need a stable coalition. And so what we have, and what we also what we have is that we have much more issue-oriented dynamic coalitions that build on that actually build on specific issues. And for these, fragmentation in principle is less of a problem. So that's the theory. And now what I did some minor empirical investigation, and it's not finished yet, but I looked at coalition building in the European Parliament in the current legislative period, and only I looked at this year. So I looked at all decisions that the European Parliament took from the 1st of January 2015 to the summer break, I think mid-July of this year. And what we actually see is that kind of confirms my initial my initial or the theoretical hypotheses. So what we see is that and that's interesting or surprising, is that actually most issues that come to vote in the European Parliament, they're actually successful. So I had 155 decisions, 149 were actually successful. Because we don't have a government that brings these to the table, it's the Commission usually. How does the Commission know that this will be successful? Or so there have to be some informal mechanisms, and I haven't found out yet what this is, but that's one thing that I still want to find out why it's actually so successful. Now, if you look at the coalition building, is that in most legislative projects, you have a grand coalition, which is basically the main conservative party, that's the European People's Party. You have the main socialist progressive party, that's the Progressive Alliance of Socialists and Democrats. And you have the Liberal Party, Renew Europe, that's the name of the Liberal Party. And they usually support most of these legislative projects. And sometimes there are other parties that support them. The Greens, for example, are often also within the winning coalition, but also the European Conservative and Reformists, which some people would already label as a far-right party because, for example, Giorgia Meloni's Brothers of Italy, or the Peace Party, so the Law and Justice Party of Poland, the former governing party of Poland, they're also part of this European Conservative and Reformists, but they're basically three far right-wing fractions. Then you have the Patriots, which are the party of Marine Le Pen, so the Rassemblement National. And you have Orban's Fidesz party in there as well. And then you have the Europe of Sovereign Nations, which is basically the German AfD plus, so they have 27 delegates and 15 are AfD delegates plus a few others. And you see within these three right-wing fractions that they have different levels of consensus. So European Conservatives and Reformists, they support about 2/3 of the legislative project. That means they play quite a constructive role in this process. The Patriots, about half of the projects. The Europe of Sovereign Nations are actually the most destructive party of the European. So they support the fewest legislative projects. The left, on the other end of the spectrum, is also a party that supports rather few, less than half of the legislative projects. Now, if we look at coalition building, you find individual instances, quite a few, where the Progressive Alliance of Socialists and Democrats doesn't support an issue. So what's the coalition that's usually formed then? It's often a right-wing coalition of the European People's Party, Renew, and then the European Conservatives and Reformists and the Patriots. So that would be a winning coalition within the European Parliament. There are very few issues where even legislation can be taken against the resistance of the European People's Party. And that's then a strange left-right coalition of the Socialists and Democrats, the Renew Party, and Greens and Lefts on the left-hand side, and then the European Conservative and Reformists and the Patriots on the right-hand side. So a quite weird mixture, but that shows you that dynamic coalition building kind of is possible, even beyond traditional left-right spectrum. That's what you actually see. So the European Parliament, despite fragmentation, functioning quite well in the current scheme. And that brings me to my conclusion that probably fragmentation as such is not such a big problem. What's more of a problem is, I would say, polarization. So if you have different poles that actually can't even find common ground, don't come to an agreement, or parties that actually see their main role not as a constructive role, but as a destructive role. So if they're really opposed, like, for example, Europe of sovereign nations, to the European project, and regardless of what the issue is, they want to torpedo these projects, that would be a problem for the functioning of the European Parliament. However, fragmentation, not so much. Are there some lessons for national parliaments in this? Well, maybe even parliamentarian systems, we might think of tweaking the design that we lessen the dependence of the government on the parliamentary majority. That might actually make legislative decision-making more dynamic, even in the national context, and that might be even more important in times where we see also greater fragmentation on the national level. But that's something I put out here, and I'm not sure about this, but something that would be a logical conclusion, at least from what I said before. Thank you very much, and now I look forward to this discussion.
Yeah.
Hi, Professor. Thank you for the lecture. It was quite stimulating. This topic is interesting. Here in Brazil, we have what one famous social political scientist has called presidentialism by coalition. So we have the presidential system, but we have a president who has to always trying to build a coalition in the legislature. And we have a fragmentation. We have a lot of parties. And I was wondering if your conclusion is that fragmentation as such is not a problem. And I was wondering if perhaps the problem is more on how this fragmentation is achieved on the electoral system, how we end up with multiple parties, than fragmentation as such. That's just my question. Thank you.
Very briefly.
Yeah. You were so.
Following the okay. Thank you very much, Niels. I agree with you. I think you're right when you say that presidential multi-party or presidential system or separation of power systems multi-party system allow for dynamic coalitions. But the thing is that the cost may be very, very high to negotiate in each issue separately. So and actually it all depends on how powerful I'm talking about national issues. I'm not, I have no idea about the EU, but it depends on how powerful the chief of the executive in Brazil, the president, is, especially concerning legislative powers and budgetary powers. Otherwise, the president has no power to negotiate. And this is why actually a strong president may be not an disadvantage, but actually maybe a precondition for the system to work. And because a weak president, a weak chief of the executive is not able to negotiate and will be in the hands of the legislature. And as some studies show, weak presidents are more prone to resort to illegal measures or even to coup d'etat because they're too weak to negotiate. So they are in the hands of the legislature. I have no idea how you transfer this to the EU, but this negotiation demands power on both sides. And if you have an imbalance of this power, then you will be stuck in all negotiation and you risk collapse. I don't know. It depends on, of course, on the country.
So thanks, Niels. I may need to read this in draft because it seems like there's some subtleties in the argument. I wasn't sure if I was following them entirely. But firstly, on your concluding idea that you're not so sure about the idea of lessening the dependence of the executive on the parliament, I think if you're going to make that suggestion, you would at least need to engage the fact that although in theory, as you said, parliamentary systems have the legislature controlling the executive, in practice, that's not the case in modern parliamentary systems, that they're all hyper-executive dominated, and parliament's control is radically attenuated partly as a result of the way the party systems function. So that dependence is already weak, and that's already seen as a problem. And I think that's true in the EU as well with the discussion of the democracy deficit. So I think the suggestion of making that dependence weaker still is quite a provocative claim to make, and one that would raise the concern that those measures are already dangerously weak, or at least that's the common position in the literature. The other thing is much more of a suggestion to think about, that I wonder if this presidential parliamentary distinction is a little bit of a red herring for your argument. That's the part where I'd like to read your draft to be sure about whether that's the case or not. But I would throw out the reforms that have been made in some parliamentary systems to produce the result that you're talking about. So take, for example, New Zealand, where in order to allow for the possibility of coalition government when they changed the electoral rules, the solution essentially was to make many issues not issues of confidence in the government. So you allow minor coalition parties to have a much freer policy role on most issues so that they can express their separate identity. Put in your terms, it's a way of having a more fragmentary system within a parliamentary system on a policy basis, but not on the basis of government confidence. So that might be a useful parallel for you to think about as well.
We stop here and you answer the 3 questions and then the second round. Okay, then.
Thank you so much. I was hoping that I get some Brazilian feedback as well, because you have this system with a non-two-party system like in the US, where even though also in the US it's a bit more complicated, but so with a fragmented parliament. You're right. So probably I shouldn't say fragmentation is no problem. I think it always is a problem, but it's maybe less of a problem than it's perceived. I guess that's more the thesis I want to make. How fragmentation is achieved. So I was thinking are you thinking of the voting system? So whether it's actually by district that creates problems, of course. District voting gives incentives for each individual parliamentarian to give projects and money to the specific district, and you have how do you call it, log rolling and horse trading and so on. So I take that point. That's not a problem so much in the European Union, where you have a representative. I mean, with exceptions, because not there are different country quotas, but in principle it's a representative, more of a representative system. Your point on the power is a good one, so that the executive, in certain, even if it's not dependent on Parliament for if it's not dependent on Parliament for being confirmed, it still needs to negotiate, of course, with Parliament. Also, the Commission has to, the budget has to be approved by the European Parliament. But I mean, one could argue is, if I'm not dependent on specific parties, I could look at different coalitions and see what I can give to them, so that you can, so there's competition among the parties, and maybe that's the way how you could negotiate. But you're right. I mean, if we have a very weak president, then that's of course a problem. James, so I'm not so much on the EU democratic deficit bandwagon. I think there's some institutional, I don't say the whole critique is without merit, but I think there are certain institutional design features that maybe have some benefit, and we should look whether, just because it's different than we do it in the nation state, that's necessarily a problem. Does this invite, so weakening the link to Parliament, does it invite all the problems of presidentialism, that we have a personal executive that, I mean, looking at the EU, I wouldn't say so, that there's a danger that Ursula von der Leyen becomes a Donald Trump. I think that's rather far-fetched. And I think it's not just in the person of, but probably the legitimacy, because she's not popularly elected, but by Parliament, even if it's not that easy to get rid of her, makes the narrow, I mean, what we see is lots of story building around legitimizing your own action. And that's what we see in the United States at the moment, like Trump's claim that he had a landslide. I mean, these are all strategies in order to legitimize exercising extreme power down the road. That's a strategy that the Commission wouldn't have in a parliamentarian system.
Clarify, I don't mean that. I mean more like the argument that you would make in the UK system, that the government happens in number 10 and number 11 and not in the House of Commons.
Okay,
and that's an argument the Commission certainly could make.
I would have to think about that. And thank you. I take your point of making coalition agreements more flexible. Of course, that could be another way inside the current rules how you could deal with the problem, that you're much more flexible in the coalition. But that's maybe also a cultural issue. So New Zealand switched to a representative system.
They switched to Germany's electoral system.
Yeah, they switched to a representative system, and so they might have where you already have an entrenched way of doing things, it might be more difficult to change these ways. But maybe by showing them the New Zealand example, it might be a way to alleviate the gridlock here and to deal with fragmentation effectively. So that's a good suggestion. Thank you.
So we have 3 more questions. Yeah.
On James's line, thanks, Niels. I found this very interesting. But let me be Oliver Lepsius, where is he, and be a little bit provocative. So isn't it a problem if in the European Parliament most legislative initiatives get passed and some majority can always be found? I mean, that's at the heart of the democratic problem in some ways, no? It means that independently of how European voters vote, the Commission will always find someone to push the project through the European Parliament. Isn't that a problem? I mean, I think this is something we should be shocked about, rather than sort of being admiring that this is a constructive approach. And now, sort of on a less provocative note, I mean, I'm also like, I would like to read the draft because I'm not entirely sure I got all the bits of the argument. I just think to some degree, it was, I mean, to some degree, you were too constructive, as it were. So I think both in the presidential system and to some degree that's been mentioned, the idea of issue-specific coalitions is something that often doesn't happen. And why doesn't it happen? Well, it doesn't happen because there's different institutions are run by different parties. And so legislatures, like in the US, for example, often have no interest at all in supporting a president if the president is coming from a different political party. Even if they would agree on the issue in question, right? They will want the other party to have a defeat and therefore not pass whatever they are proposing. So I think that needs to be part of your argument somewhere. The second one on sort of fragmentation and how to remedy it in parliamentary system, that's just a sort of question. I wonder what you think of the recent proposal on semi-parliamentarianism. The ideas of a second chamber where there might be a difference between one chamber is the fully representative chamber that passes all legislatures. I'm not explaining to you, I'm explaining more broadly. And the other chamber is a chamber that would be a sort of confidence chamber and would therefore like enable the government to stay in place and thus sort of avoid the kind of risks that fragmentation brings with it. Thanks.
Yeah. No.
I have 2 points. The first is a very short remark. I would be extremely interested to have some comparative perspectives, and I would find it highly interesting if you could also look to some other perhaps national systems to make your point, which I also have the feeling that I should read it, but I found quite a lot quite intuitively quite plausible. I also do see Michaela's point, and yet at the same time, I've the feeling in Germany we don't get anything done because we have a very strong and cemented more or less big coalitions in which you could usually only agree on not changing too much. In Europe, you get everything done, and an alternative. In particular in Germany, with the far right parties becoming a real threat, might be something like an open marriage coalition, including other parties, where one would agree that government may find among a number of parties, and that could also be done on the European level, among a number of parties changing majority. That would, of course, diminish the power of the parties. But for this reason, taking into account also the coalition side is important. Diminishing the power of parties may not necessarily be a bad thing in itself.
But one short question. I was struck, like Michaela, by the success rate in the European Parliament. But is this so different from national parliaments? I guess even in national parliaments, there's much legislation that is not really disputed because it's highly technical. And maybe we have a similar success rate in other parliaments. The other remark, contrary to James, I share your lesson you want to learn by weakening the link between the government and the parliament. And you might look at again at the Swiss model, where the government is made up of representatives of the 4 biggest parties in the last election, regardless whether they can work together or not, the parties. And this works quite well. And the parties in the parliament are free to take other positions than their representative in the government. Maybe the system only works because there are additionally means of direct democracy. The people can be asked on any question they want, but still that might be an idea.
One last, Oliver, and then around.
It's not a question, it's rather common to Niels Jansen's remark. I don't understand your argument, Niels, when you're saying people complain in Germany we don't get things done because we have coalition government and we have to compromise. I don't see that point at all. The so-called Ampel coalition was, I don't have the figures now with me, the most successful coalition in terms of the number of bills that have been passed in the Bundestag. I think we had hardly ever one legislative period with more bills passed than the Ampel coalition. So your point cannot be a point in terms of numbers, figures. The issue is not that we do not pass laws, as you said, and that this might be an indicator for some deficit in coalition government. I don't see that point at all. I think you are mistaken on that. The complaint in Germany rather is not about legislation, it's about bureaucracy. And the point would be we have too much laws because they create too much enforcement. And the enforcement then is perceived as a problem of too much bureaucratic infringement. So your argument would rather go the other way around. Too much laws because of coalition government that leads to much enforcement that is then accounted as too much bureaucracy. If we have some, so to say, regulatory problem, it's not within the legislative branch, it's rather in the executive branch. And this has to do with federalism. The federal legislature enacts laws without taking into account the conditions under which these laws have to be enforced on a very local level. The usual enforcement agency in Germany is the city. Yeah, it's not even a federal state, it rather is the city. And that's where the issue is. The cities have to enforce laws that are drafted in Berlin with no regard to all the enforcement restrictions that play into the enforcement on the very, very local level. So I think that's where the issue is, and not where you put it.
Thank you. So Michaela, isn't that a problem? So I think I wasn't quite clear in my presentation there. So you have all kinds of that doesn't mean a directive proposed by the Commission immediately adopted by Parliament, but successful votes can also be votes that ask the Commission to change certain points of the proposal. So it's not just that the Parliament is always in line with the Commission, but you somehow find coalitions around certain issues. And I was wondering how that works, because has to be some coordination device, how you do it, that you have so many successful. So I don't know. So that's something I want to find out, because that's I found the number quite unusual. I have, so one point I noted here, but I don't know, defect of president was but defeat of president. So I guess yeah, okay, but and semi-parliamentarian, that's an interesting, Steffen Ganghoff. So that's an interesting proposal. I really liked it, and I think that's the one that inspired me for this. So the task wasn't really to say something new, but rather about fragmentation. But if you think of new institutional designs, I actually quite like the proposal. So I mean, you explained it. The idea is that you have one parliamentary body that supports the government, and then you have another parliamentary body that is really focusing on legislation, and so you have different ways of coalition building. Then comparison, Niels, to national systems. I think that's an important point. I mean, these numbers don't tell much if you don't really compare it to national systems. The problem is, I looked a bit at the German parliament. You need roll call votes in order to make these kinds of, so namentliche Abstimmung, you would say in German. That means you would have to see which parliamentarian actually supports which proposal in order to see which coalition kind of supported each vote. If you just have the vote tally, then you can't really tell all that much. In the German parliament, you don't have that many roll call votes. In the European Parliament, most of the votes are actually roll call votes. In the German parliament, it's really the exception. I looked at a table in the German parliament, and I saw, oh, did they only take 6 decisions this year? So that's really an inactive parliament. But no, the reason is really that most of the votes are not roll call votes. So that's why comparison is probably difficult, but maybe there are other national systems. Open marriage coalition, I think in the South African context, you call that coalition of national unity. And James, can you probably tell about some of the problems with that? But I mean, it would go into the New Zealand example of James, right? That you have maybe a larger coalition, and then you within the coalition you find might have problems. I mean, let's say you put the Greens in the German context also into the open marriage coalition, then you wouldn't really, I mean, then you have the left and the AfD as the opposition. Well, that would be the ideal scenario, is under different aspects. What do you do if government isn't functioning well? Well, you look at the parties that are outside of the coalition, so that would probably strengthen the fringes as well. So you would have to think about the effects of these kinds of the Swiss example is interesting. So I was, for a long time, I was actually quite skeptical about direct democracy and thought, but the more I see the problems of the parliamentarian system, I actually quite like the Swiss system, that you have a government that's not that dependent on the current parliamentary majority, that you have actually frequent direct democratic elements. I think it doesn't work if you ask the people every 15 years, do you want to be part of the European Union? If they don't have any experience with direct democracy, that doesn't work. But I think in the Swiss example, we have constant, so where people are actually trained to think about certain issues and then vote on them, that might be an actually much better use of direct democracy. And on Oliver, yeah, I mean, I don't know the numbers, so but it's a valid point that you're making, that probably the Ampel coalition was much worse in its marketing than actually in its output. But the constant bickering between the different parties probably didn't help in the outside in the outside perception of the coalition. Thank you so much.
I think that was it. No more questions? No. Okay, so thank you very much.